be when you give away your brain away, you end up addressing the challenges, the symptoms of the problems as if they are the problems themselves. Then you know that we are a society that is giving away its brains. So in SALGC, we refuse to give away our brains. We say we know when these are just symptoms and we know what solutions should be. The greatest and the biggest solutions that our country is facing, it's nothing else but lack of leadership. So at SALGC, our purpose is to develop leaders so that they see in themselves what the maker in that his philosophy has made and his purpose has made in making a man. Because God's plan on earth, it's surrounded around a male, which is a man. So with the fallen man since the Garden of Eden, we have seen what we are seeing happening today. It has been a continuation over centuries. And we are not fooled or delusional as SALGC to think that we can bring solutions of these problems alone. We are aware that the challenges that engulfed our communities and homes and our families are insurmountable, and we can only eliminate those challenges in partnership in a new contract with society, all other MPOs, leadership like yourself, leadership Bikwani, government, business, and everyone else. If we come together and we focus on the core challenge or the core problem, not the symptoms, we will eliminate the challenges that engulfed our community. So that's our philosophy of our land, of this club. However, we went further and say it would not do justice for a man, as God said, he is lonely and he needs a partner who will help him drive this. We thought that if we don't get a voice of our partners, which is women, although the club is made specially for men, if we don't get the voice of women, we will not do justice on the solution, on the challenges that are facing our communities, because women face them frontline every day. Every day when they raise the boy child, when a father or a man has run away. Every day when they raise a daughter who wants a father figure in their lives. Issues like that. So we decided in SALGC that we are going to allow women to be part of SALGC. Although they will not take the membership of the club, because the target is to get this man who has fallen to join the club and work as God has gave that instruction. So we felt that let's bring women into the club so that we can hear their voices. So we brought women to the club and then we gave them a desk within the club and we called them Friends of SALGC, which is the abbreviation of the South African Leadership Gentlemen's Club. So that's how we brought women in. So they have a desk in the club where they have their voice, where they contribute to the program design and ultimate execution, because most of women we know today, they've got impeccable skills that might not be available in SALGC. So when they raise their hands and say, I'm able to assist the club so that it can achieve their mandate by non-monetary issues, issues by being able to assist you with my expertise and all that and my advices, we welcome that. So women, if they are new here, both on Facebook Live and on more live radio station, and even here in Zoom, we want you to know that we appreciate you, we love you, and you are our social partners. You were given to us by the Almighty, so we cannot be without you. We thank you very much. So in the same breath, within the club, we have ambassadors, young men who are going out there and spreading. They say they make it yoke, the virtues and the cultures of SALGC to their counterparts, to their peers, to their friends, to their brothers and sisters out there. So they take the values of the club and they go out there and they influence the community, their friends, their peers, so that we don't have bullying like the one we have recently seen in Venda, where a little child ended up taking her life because she felt that she wasn't worth. So we have these ambassadors in the club, the young men, and women who would be, obviously women will be with the Friends of SALGC. So we are encompassing the whole family in this club to ensure that the mandate is being achieved. However, the man is always, in this case, put in the forefront as a head and the foundation of the family to ensure that he drives this thing. So the challenge is out there to men who are here for the first time, men who are on More Life radio station for the first time, men who are on Facebook logging in for the first time. You need to know that this club is for you. You have no excuse now. If you need issues to be addressed that are men related, SALGC is the place for you to get those issues addressed. Then as we move forward, uh, I'm not going to go into the founding pillars of the club and what they are, but I'm going to go to our programs. Our programs are derived from these 5 founding pillars, which can be visited in on our website. They are pretty much detailed there. I've always got feedback that we are very clean on the website. We are detailed on what our position is for. So our programs, all of them emanate from those founding pillars, especially, and for instance, the program that we are on today is a bi-monthly leadership lecture where we address issues of national importance or significance. This program goes with our first pillar of mental liberation of a man. And as it goes, we also say our motto of the club, it's reviving human conscience and bringing back hope. So once you put that together and you look at it, we are taking the man's brain to ensure that he internalize wisdom and knowledge as a leader of a family, that these things become second nature to him. We know that our culture is such that such things as wills and all these things are very foreign to them, more than anything. So hence we bring such topics and we address them under this program of bi-monthly leadership lecture. So we have this kind of a program twice a month. As we're having it today, we'll have it the Sunday after the next one. Another program that we are running, we have a program called Lewala Banna, which we recently launched about a month or 2 ago. Lewala Banna is a Sepedi word, which means a cave for men. So as the man who's running this program, one of our leaders here, very young and brilliant, Leadership Sekhale, he always says that in the previous days when men were hurt in a war anywhere, they will run to the cave, not because they are running away from the fight, but they are going there to just lick their wounds so that when they come back, they're strong as ever and they're able to tackle whatever challenge that is attacking them or their families. So in this case, it is not a physical war that you run to Lualaban or the men's cave. It says to the men who are here, the men who are listening on More Life, the men who are on Facebook, when you have challenges in life that have beaten you so bad, and we have made so many mistakes and you don't even know where to run, and the society is alienating you and you want to start afresh, there's always hope. You can come to SALGC. This is where you are not going to be judged. You can never say, I've gone too deep and there's no way of coming back. As long as this club is here, there's hope for every man and every boy child in this country. Come back. Here are men sitting here. They will not judge you, my brother. We'll sit and talk and get things into the right perspective and move on. Lewalabana also addresses the legal challenges that men are not aware of. There are legislative rights, those who have been punished and in terms of not being allowed to have visitation or access to their children. This program is also meant to assist them to find the way forward on how to navigate such challenges in life. Because if we don't have these outlets for men, we will forever see the increases of the symptoms of lack of leadership, where men will continue killing women, killing their own children perpetually. And we see that, unfortunately, as their problem, while it's only a symptom of the bigger problem. So at SALGC, those are programs that we are addressing. We have another program, the it is a national essay writing youth competition. It's going to be on its second year this year. Last year, we had it in its inaugural year, where we got all the youth of the country to write an essay on the topic of toxic masculinity. Here we wanted a boy child to do a research by asking my umalume, uncle, umama, daddy, my teacher, my friend next door, the uncle next door, my mother, whoever, my sister, and everybody. We actually needed to get the nation in transit to learn on this, because as the kids start asking you what is toxic masculinity, you start engaging them themselves. That's the nation talking. And they learn in the process to self-restrain on the behavior that is toxic and out of line. So there's many other programs that are coming, and I've been hearing from the office that there's inundating of calls that comes from leaders of SALGC passionate about bringing new programs. And luckily our programs are being vetted through our executives and the board to see if it meets the standard through which we want to address the challenges. So there are many other programs that are coming. And in a nutshell, I want to call on all men, irrespective of a class, race, or whatever. Your class, your academic qualification, professionals, we are calling you to come to SALGC. Bring those brains, give back to the nation, like one of our leaders, Leadership Mbulelo, is doing now. There's many others that are coming to the club and doing the same, but we need your brains on how we can really make this a social movement that will live beyond us when we're no longer there. The one that will be building generations that will be able to take our nation forward. So it is an open challenge to come to call to all those professionals to say, SALGC is not only for those guys there. It is for the nation, it is for everyone. We're calling every one of you. And all these programs that we are bringing, we are unfortunately not having any financial backing. Most of the things the club is doing by themselves. If there's anyone who's got interest in funding any of these programs, go to our website and contact us via the website. We'll be able to engage you and see how we can work together to get that. Or even a network on connection of who can fund these programs. We'll appreciate that. Ladies and gentlemen, today it's not really about me. I always say my passion for this club is extremely, extremely high. I will talk nonstop. But today it's about our guest and you, most importantly. The topic of national importance, Mojalefa Iwolio, will be done. We work hard, we buy properties, we invest in all these things, but do we know what will happen? Or do you have a say of what will happen with all our investments and our children and all that when we are gone? Or we just don't care, we won't be there. It will be another Muvango that he was brilliant enough to put all this together, but he hasn't been wise enough to ensure that the succession plan, he knows where he has put his things, everything, the ducks are in a row. It's a challenge that we have. We always see these things as a foreign things, and it's very unfortunate, but we want to make sure that the SALGC, for those who are able to listen, as the Bible says, they will hear. And for those who are able to see, they will see. So I'm going to tell you who our guest is today. Leadership Mbulelo Bikwani, short bio today. Mbulelo is married to Nombulelo. Did you hear that? Mbulelo is married to Nombulelo, blessed with 3 daughters. Nina, una 34 years. Lihlumelo, una 20. And Lelisibini, una 17. With his wife, they are founders of Isiseko Family Institute with Archbishop Mohoba and Judge Yvonne Mohoro as patrons. The institute is involved in nation building project through a building of strong family structures. A senior director with experience in HR, transformation and operations within large corporations, including Rentokil Initial, Computer Corporation Services, and South African Medical Research Council. He is the current executive director of Socrate Consulting Services and has consulted for a number of corporates and organizations in a number of organizational areas, including organizational design, strategic planning, diversity and inclusion, human resource management, relationship objectives, and executive search. Mbulelo is an accredited labor mediator and arbitrator. He's also a ADR UK accredited commercial mediator and arbitrator. He is an experienced and skilled facilitator. And I'm sure you are listening and asking, how does he have expertise on what we're talking about? Because I haven't gotten to that. He served and still serves as on a board of companies, organizations, trust, and as chairman and or director and or independent trustee. Until March 2017, he was chairperson of Council of Cape Peninsula University Technical, CPUT, and University Council Chairperson Forum, SA Forum of the 27 University Council Chairperson. He also consults in the area of estate planning and act from the time to time as an executor of agent of deceased estate. He is also chairperson of the Continuation Acclaimed Benefits Provident and Pension Fund. Until April 2018, he was the chief executive of the Desmond Tutu and Leah Tutu Legacy Foundation. He is a law graduate from the University of the Western Cape, Bush, and a member of the Institute of Directors, IOD, and Fiduciary Institute of South Africa, FISA. With that said, I want to hand over to Leadership Mbulelo. Over to you, my leader. Let's just jump into it. You are on mute, Leadership.
Can you hear me properly now?
Yes, yes, we can hear you now.
You can hear me. Thank you very much for the introduction, and thank you for the invitation. We feel humbled by the invitation to talk about really an issue that we were also starting to see that it's a big issue. There are things that you don't know until you get involved in them, how big they are. It is like I was saying to someone, I have known Judge Zondo as a good judge, but I haven't known him as this good. Now that we've seen him sitting on the Zondo Commission and displaying his competency. So the issue of estates and deceased estates is something that I've studied at university. And it is not an area of law that I ever planned to get involved in. But a friend of mine made sure that I get involved in it. Because in 2003, the late Dr. Mandla Chabalala, who was a very close friend of mine, said to me, you know what, the day I die, I want you to be the executor of my deceased estate. That was a long time ago. So I just thought, Umsheng is just talking. I mean, why is he thinking about death now? We still have a long way to go. I mean, then Mandla died on the 28th of December, 2017. And I had his will with me, which appointed me as an executor of his deceased estate. And that was the first time I have delved into deceased estates. And as I speak to you today, I think I must be having about 9 to 10 estates that I'm currently dealing with, since coming from that estate of Chabalala that I did. Now, Mandla's estate was quite a complex estate.
Sorry, my dear, please remember to share the screen.
Yes, I have not started speaking on the screen.
Oh, okay, sure.
Yeah,
thank you.
Yeah, I'll definitely. So Mandla's estate was a very complex estate. It was an estate, it was a joint estate, number one. It was a joint will, number one. So just to deal with a joint will is a complication itself. And it had business interests, it had property, it had shares, it had investments, and then it had a trust that had to be established, a family trust that had to be established. And in the process of dealing with the estate, one of the beneficiaries died. Now that's another complication. But it is one of the work that I'm very proud of, because I managed to wind the will, the estate, in a space of 2 years, short of about 12 days. So I've winded the estate within 2 years. It was just 12 days short of 2 years. Now, you don't do that when with a complex estate like that, number one. Number two, we have a serious problem. And I really appreciate the Gentlemen's Club, which really is focusing on the things that you are doing. One of the things that you need to take into account is how do we challenge the master of the high courts in the country to serve our people in the manner that they deserve to be served, particularly people who have lost their loved ones, who depend on money that is at the hands of the master. I managed to finish this estate in 2 years, within 2 years, because I had to fight. I had to put up serious fights with the master, making sure that they respond to emails, making sure that for instance, I'll give you a simple example. They will tell you that they have posted a letter with a query. And I'm saying to them, why don't you post the letter and email and scan it also? Post it, yes, I'm not gonna say don't post it. Post it, you want to post it, but also scan it to me so that whilst the letter is coming, I'm able to respond. And this thing will move faster. So the last fight I had was when the liquidation and distribution account has been on the advert for 21 days. And then after 21 days, the magistrate of where the estate has jurisdiction would be the one who will then give you a go-ahead to do the distribution by stamping the will or stamping the account, the liquidation and distribution account. I got to the magistrate's court and I was told they were not too sure whether the magistrate is going to stamp the account today or any other day. I said to them, no, that's fine. I'm going to sit here until he stamps it. I'm not going to leave because I want it today. You can't tell me there's nothing that the magistrate must do because this has been on his or in his desk for 21 days already. So all what he needs to do is to put a stamp. And I sat there for something 1 hour, 2 hours, and after 2 hours, they eventually stamped the account, the L&D account, which gave me the right and entitles me to do the distribution in terms of the will. So I thought, let me quickly deal with that part. And then I'm going to then move to today's topic. Today's topic is a question, and as I said initially, I am taking rather a longer route in answering this question. I could answer this question in 5 minutes. The question which says, why would you have to have a will? I can answer that question within 5 minutes, but I've decided to take a longer route. I've decided to say, this is what you need in order for you to have a will, and these are the reasons. Secondly, this is what happens if you don't have a will, and this is what happens to your estate, to your assets. And that's what is called testate and intestate. At some point in each and every one of our lives, we will be faced with some death within our circles, whether it's a friend, it's a family member, a parent, colleague, or child, but within the closer circles we have, we will experience a death. And because that is certain, because that is guaranteed, it is therefore important that when we die, we have answered the following questions. We need to answer these questions before we die. Firstly, if I die, who will control your estate? Who will look after your minor children? Who will control any monies for the maintenance of your dependents? Where and how will you be buried? Who will inherit your belongings? Who will pay for your funeral? These are questions that we need to answer now whilst we are still alive, so that when we don't speak, we don't breathe anymore. When we can't breathe anymore, we are able to let those that we leave behind, particularly our wives, with some directives. These are future directives that we need to actually put together now. The aim of this lecture is to assist you in answering the above questions and being able to understand the importance of estate planning for your final days, as well as what issues need to be considered and addressed after the passing of someone. We'll focus on areas such as estate planning, just to know what it means, preparing a valid will. And you would see here, I'm not saying preparing a will. I am saying preparing a valid will. The validity of a will has created so much case law in our courts because it is the issue. You may have a will, that's not the issue. Is your will valid? It's the issue. As well as what to do after someone died, as well as distinguishing between intestate and testate succession. Although many people avoid thinking of their own death, and particularly of those of the people they love and care for, it is important that we ensure that the final distribution of our assets and belongings, as well as the care and maintenance of our dependents, is done in a fair and respectable manner. And the only time we can make these arrangements is when we're alive and when we're of clear and sober mind. If you do not plan ahead, your family may be left with your debt and may have to make very difficult decisions on your behalf. I will also address controversial issues surrounding death, such as the impact of current legislation on the customary traditions practiced by many African cultures in South Africa. In dealing with the concept of succession, various legislation may be consulted, and those legislation, I'm not dealing with them, I'm just really running through them. First one is the Births and Deaths Registrations Act 51 of 1992, Administration of Deceased Estates Act 24 of 1913, Wills Act 7 of 1953, Interstate Succession Act 81 of 1987, and the Reform of Customary Law of Succession and Regulation of Related Matters Act 11 of 2009. What is estate planning? Estate planning is formally planning and preparing for what will happen to your financial affairs, your children and your belongings on your final day. Let me say this up front. As I'm talking about husband and wife. So if we have our wives here, they mustn't think I'm talking about husbands only or men only. I'm talking about both of us. And
yeah, sure.
Yes, and leadership, I'm sorry I did not. I have seen quite a number of members of the executive of isiSeko Family Institute having joined, and I really want to say to them, unfortunately, I was still thinking about doing this presentation for isiSeko, and I don't know how the Gentlemen's Club ran ahead of it. We've just discussed with my wife that we need to do this kind of presentation, and I didn't speak to my Umchana who then facilitated this.
Yeah.
Just want to
No,
acknowledge.
it's vibrations, leadership. It's vibrations.
Yes, I just want to acknowledge them on the platform.
Thank you. You're welcome.
Yeah, and by planning for your final day, you are able to decide what should happen to your assets and your children. This will also prevent unnecessary conflict between family members, as your wishes will be set out in your will. I know those who have younger children, this is a difficult task. It was difficult for us when we had to do our will with my wife, and then there's a question that says, what happens if you die in the same accident together? And you think, no. You know what? I don't want to think about this. I don't want to think about a situation where if we die in the same accident together, what will happen to my children? Because they were still children then. They were 3, 4, 5, 6, but those are realities that we need to think about. Those are things that we need to start to find a way of dealing with. The most important part of estate planning is being able to decide for yourself what will happen to your assets and family on your last day. The only way in which the law will recognize your intentions of what would happen to your estate is if your intentions and wishes is documented in writing, and that is called a will. The only way in which the law will recognize your intentions of what should happen to your estate is if those intentions are reduced in writing in the form of a will. I've told you now I have about 9 to 10 estates on my table, and they are all from Black people. Only one has a will. Only one has a will. Others, they are intestate. There's no will. Yeah. And the complexities of dealing with intestate, you will see when I deal with the examples when someone dies intestate, because there are about 9 rules that are captured in the Testate Succession Act. Section 1.1 has 9 rules that you have to go through in dealing with the intestate succession. Should you fail to prepare a valid will prior to your last day, you will be said to have died intestate, and the laws of intestate succession will determine how your estate is divided. If, however, you leave behind a valid will, you are considered to have died testate, and your estate will be distributed as per your wishes. So, testate, it's a death with a will, with a valid will. Intestate is a death without a will or with an invalid will. Yeah. So you may think that you have a will. If your will is declared invalid by the master, then immediately your death is then regarded as intestate succession. And the laws of intestate succession will determine how your estate is divided and distributed. The law of succession deals with the rules which apply to the division or distribution of the estate of a person on the last day. The law of succession can be separated into two categories, testate and intestate succession, which we have dealt with. Intestate succession is governed by the Intestate Succession Act 81 of 1987, and the laws of intestate succession come into operation when a person dies without leaving a valid will. It's either you don't have a will altogether, or you do have a will, but it's invalid. Or where the deceased has left a will which only deals with certain parts of the deceased estate. For example, your will only leave your house to your children, but you do not say what must happen to the rest of your belongings. So your house will be dealt with in terms of testate succession, and everything outside of the testate of the will be dealt with in terms of intestate succession. The heirs appointed in the will are unable, that's wrong. The beneficiaries, because there's a difference between beneficiaries and heirs. Heirs are those people that are defined by the law when you have not left a will. The law defines section 1(a), those rules of intestate succession define the heirs. But when you have a will, you don't have heirs, you have beneficiaries. So the will defines beneficiaries, but the Intestate Succession Act defines the heirs. So you can't have heirs appointed in the will. I am sure I was writing in a rush there.
Oh, no,
so the beneficiaries appointed in the will are unable or unwilling to inherit, or the heirs or beneficiaries have died before they could inherit, and the testator has failed to nominate someone else to inherit in their place. So you have followed the various rules until you get to rule number 3, rule number 4, and you still can't find an heir. Then definitely that becomes intestate. Testate succession, on the other hand, is regulated by the Wills Act 7 of 1953, and the provisions of this act become applicable when a person dies having lived a valid will. These two branches of law are ideally important as they will regulate and formalize the manner in which your estate is administered on your last day. Planning for our last day, as well as what the consequences will be should we fail to prepare a valid will whilst we are alive. This is what I've just explained. Dying with or without a will, with a valid will, the laws of testate succession applies. Your estate will be administered by the Master of the High Court through a duly appointed executor or representative, and it will be divided as per your instruction in your valid will. Without a valid will, the laws of intestate succession will apply. Your estate will be administered by the Master of the High Court through a duly appointed executor or representative and divided in terms of the intestate. Come again?
There is a network challenge there, leadership.
Can you hear me?
I can hear you.
You can hear me. Okay. Should we proceed?
Yes, please, we can hear you.
We can hear you clearly, Dad.
Thank you.
You can proceed. We can hear you clearly.
Thank you. So if you die without a valid will, the laws of interstate succession will apply. Your estate will be administered by the Master of the High Court through a duly appointed executor or representative, and it will be divided in terms of the Interstate Succession Act 81 of 1987. Preparing a valid will whilst you are alive is a very important aspect of planning your last day. Having a valid will gives us peace of mind that when our last day comes, our wishes will be followed, and those things or people which were valuable to us when we're alive will be provided for and taken care of as the way we would want it to be. Preparing a will requires careful consideration and planning. You need to be mindful of your assets and debts, as well as who you want to leave your belongings to, bearing in mind issues such as the following: your marital regime. You don't just write a will when you're married. you need to think what's the impact of your marital regime on your assets. The second thing you need to really take into account is the future of your children and your spouse, as well as who do you want to be responsible for making sure your last wishes are fulfilled after your last day. In other words, appointing someone you can trust and who will administer your estate as per your instructions. Let me just pause here and emphasize the importance of this part. It can never be overemphasized. You need someone you trust. You need someone you trust. In the will of my friend, I had at one stage 10 million rands in the account, and I was the only person who can transact on that 10 million rands. And that's the time I realized how important it is to find someone you trust. You have that kind of money with someone you don't even know. I can do transfers because I'm the executor, because what happens is that after you have received your letter of executorship from the master, the first thing you do, you open up what is called an estate late account. It would be, for my friend, an estate late Mandla Chabalala account. And that account, I am the authorized signatory and transactor on that account, no one else.
Yeah.
I thought I needed to stop at this point and make this point much, much more important.
Thank you for that.
Yeah. Now, one of the first things we said you must be aware of is your marital regime. Let's talk about what is marital regime. In South Africa, we have 3 types of marital regimes, each with its own consequences should the last day visit one of the spouses. These regimes are as follows. Marriage in common of property, which is the much more popular one. And in marriage in common of property, both parties share a joint estate. And unless you prepare an ante-nuptial contract, this regime will automatically apply to you. When your last day comes, your spouse is automatically entitled to his or her half share in the estate. This means that you cannot bequest your spouse's half share to someone else. You may probably with your half. If we have 5 million in the account, 2.5 million is mine. 2.5 million belongs to the deceased estate. Now, if there is a will, the deceased who the deceased estate has been created on behalf of would have given a future directive on what that 2.5, what must be done with that 2.5. You can still say, giving R1 million to my wife, I'm giving 250,000 each to my 3 kids, and I'm taking the balance of that 750 into a trust to look after this and that and something else. So that's what marriage in common of property is. Example, A dies jointly owning a house, 2 cars, investments, and a business with B. B is entitled to half share of everything that A owned and half share of all liabilities. You don't just own the assets, you also own the liabilities.
Nice.
And then the second one is marriage out of common of property. Both parties have a separate estate. In order for your marriage to be governed by this marital regime, you need to draw up an ante-nuptial contract, an ANC. Upon the death of either spouse, the surviving spouse is not automatically entitled to a half share in the deceased spouse's estate. So we have been running 2 accounts. You've been running your own account, and I must upfront say, within our family institute, we don't support any marital regime, but in community of property, and we have our reasons for that. Biblically, there is no marriage out of community of property. The biblical marriage is in community of property. And I know people come with MBA and PhD questions. They ask PhD questions. And I always tell people that don't ask me questions that you must ask God. You better ask God that question, not me. Because God knew very well when he said the 2 of you are going to be one. So marriage out of community is you need to draw up an ante-nuptial contract. Upon the death of either spouse, the surviving spouse is not automatically entitled to have share in the deceased spouse's estate. The deceased spouse can decide what they want to do. They can leave all the assets to their children. They can leave all the assets to their mom, particularly with men and their moms. Men and their moms. If mama's boys, if the wife is not awake, is not alert,
Yeah.
when your husband dies, everything would have been shared or left to the mom. Example is A, married to B, dies owning a house, 2 cars, investments, and a business. B is not automatically entitled to anything that A owned and not responsible for any of A's liabilities, which is a good thing. The last one is marriage out of community of property with accrual. I was just talking to one young couple that were married in this, and they didn't understand it when they got married. And fortunately, I spoke to them before they got married. I said to them, come to our course before you get married. And they said, no, we've done our research. We know what we're doing. All what we need from you is a notary. Do you have a notary that can help us draft an ante-nuptial contract? And I said, well, if that's what you say, I'll send you to the notary that we work with. And we sent them. Now, very soon after that, the marriage didn't go well, and they didn't understand what they were getting themselves into through the marriage out of community of property with accrual. What happens in marriage out of community of property with accrual? In fact, what marriage out of common of property was trying to do in 1984 when the matrimonial property regime was amended and revised, was that they tried to take the marriage in community of property and marriage out of community of property and merge them into one property regime. So in a sense, marriage out of community of property with accrual gives you a little bit of in community and a little bit of out of community. And you will see when I'm giving you an example on how it works. Both parties have separate estates, but at the end of the marriage, and if one of the spouses die, they will share in the accrued profits only. Just the accrued profits made during the marriage. And I'm giving you an example. A married B. Before marriage, A owned a house worth 500K and B owned a car worth 195K. They divorced 5 years later. The house has appreciated to 750K and the car depreciated to 110K. The accrued profits are in the house and they are worth 250K, which then means the settlement will be that B is entitled to 125K of the 250K profits in A's house. The young man I spoke to, he said his wife is trying to rob him. And I said, no, she's not. She's not. This is how out of community of property with accrual works. And now, if you don't have 125,000 to pay to B, B is entitled to actually go to court and say to the court, you must sell your house so that you can pay him or her the 125K. Which is what is common. And bear in mind, we are divorcing now, we are no more friends. We are no more friends. I'm not your friend. These things are dangerous. They are dangerous. People must know what they get themselves into before they do. Let's talk about the Wills Act as we venture into testate succession. The Wills Act provides certain strict requirements which must be adhered to when drafting and executing a will. If you fail to meet these requirements, the will may be declared invalid by the Master of the High Court, and your estate will be administered according to the laws of interstate succession. In other words, it will be as if you died without a will. Section 2 of the Act provides that any will shall not be valid unless the formalities contained in the Act have been complied with. The reason for these strict requirements is to prevent people from committing fraud and misrepresenting the true intention of the testator. The most basic formalities provided for in Section 2 of the Wills Act can be summarized as follows. You must be 16 years old or older to draw up a will. And not just 16 years old or older, you must have the mental capacity to understand fully that the document you are preparing or signing is a will. The will must be in writing, must be signed in the presence of at least 2 competent witnesses. I don't think that's what the Act says. I've heard this. Yes, the Act does say. The Act does say competent witnesses. I left competent there. So at least 2 competent witnesses. Now, competent means what you have had in the beginning, 16 years old and have mental capacity. That makes you competent.
Okay.
So equally, the witnesses must be competent. Who signs in front of each other and in front of the testator? So when you're signing a will, everyone must be here. Can't sign and scan it and send it to someone. It invalidates the will immediately. You must be in the same room at the same time. Each and every page must be signed by the testator as well as the 2 witnesses, and in the presence of each other. Now, this particular requirement, for some reason, with time became relaxed and relaxed and relaxed, because what is now acceptable, I think it must be because of some case law. I just didn't have the time to go through and check what the authority of the current practice now, because the current practice is the witnesses can sign the last page. They don't have to initial every page. The testator is the one who must sign and initial every page and then sign the last page. But the Act does say each and every page must be signed by the testator as well as the 2 witnesses and in the presence of each other. So what am I saying? I am saying whether you initialed all the pages or you did not initial all the pages, your will still be valid as far as this requirement is concerned. So whether you signed all the pages or you did not, it's still valid. And I am going to check what authority is there, because a number of wills that I've seen these days signed by the witnesses in each page. If any person signing a will is unable to write, now unable to write does not mean literate. It can mean that in the same way, with my friend was a PhD, but at some point he got so sick that he couldn't write. And if you can't write your signature on the will, you then must make a mark, even if it's a cross, whatever mark you make, could be a star, it could be whatever you regard as a signature. But you must do that in front of a commissioners of oaths, so that the commissioners of oaths can certify that, yes, this is your signature. The mark represents your signature. Any changes made to the will must comply with the Wills Act. Now, what that means is that if you make any change in any clause of your wills, you must follow the same requirements that you started with when you were actually putting together your will. How to cancel a will. Executing a new will in which you expressly revoke all previous wills and codicils executed by yourself. Now, codicils are annexed charges and any statements that are attached to the will. So how to cancel a will? You execute a new will. And in that new will, you say, you have a clause that says, I am expressly revoking all previous wills and codicils that have been executed by myself. That then makes this will to become the valid one and supersede any other will that is there. The second way of cancelling a will is you destroy the will, e.g. by burning it or tearing it up. Third way is cancel the will by drawing lines through it and sign. This must be done in the presence of the 2 competent witnesses. You must acknowledge that such cancellation with your signature, that's how you acknowledge the cancellation, you sign on it after the 2 lines you sign, as well as the signature of the two witnesses, which signatures must be made in the presence of each other. If you do not want to cancel the whole will, but only certain sections, then you must only draw lines through those sections you want to cancel. The rest of the will automatically remain valid. What are the contents of the will? What are the contents of the will? The first content of the will is the executor. Whom do you choose as the executor? I appoint X as my executor, and I'm giving him all the authority and the powers that I would otherwise have had, have I been alive. Full stop. And really any other authority given by law. So you appoint an executor. An executor is a male person, and an executrix is a female. You need to give careful consideration to who we want to appoint in such position. My leadership, it's fine, people can make notes, but I am going to make the presentation available to you.
Thank you very much, leadership.
Yeah.
Appreciate it.
Yeah.
Thank
So
you.
anyone who wants it can have it.
Oh, appreciate.
Yeah. So you need to give careful consideration to who we want to appoint in such position, as this person will have the power to manage your financial affairs, make decisions on behalf of your estate, be in charge of distributing your assets as per your instructions in your will. Let me give you another scenario of how important this person is. If your will has an element of problems with liquidity, the executor must decide what he is going to sell to make sure that your will is liquid again. If your will doesn't have cash, you can't pay for things, for the liabilities of the deceased estate, then the executor must decide. I mean, I know with one of the estates, I now deciding to sell a car because I need money to pay some of the rates and and some of the overdraft and all those things.
Right.
So that's the kind of person that you need as an executor. It becomes quite frightening when you don't have any other property but a house. And the executor will have to sell the house. Yeah. It is therefore important that you choose someone who is trustworthy, responsible, and who is able to manage finances well. Your executor must also be solvent. Can't have an executor that is insolvent. Your executor must testify before you and satisfy you that actually they are solvent.
Very important.
And they must prove that they are over the age of 18. And does not have to be a family member or friend, can also be an attorney or even financial institution such as your bank, or someone competent to handle legal and finance issues. The choice is yours as to who you want to appoint, and no one can force you to choose them to manage your affairs. The second content of the will is choosing your heirs and beneficiaries. In this case, it would be beneficiaries because it's a will. In your will, you will set out what will happen to your assets on your last day. Below, we look at the type of people or institutions you can nominate to inherit in terms of your will. One, it's unborn children. You need to start to think about your unborn children. You can't just have sex and not think that you'll have children.
Yeah, for sure.
Unborn children and even children who are not yet conceived can inherit in terms of a will, because the will can say, I leave this to my children. That's what the will say. Yeah. Adopted and extramarital children, adopted and out of wedlock children are not treated any differently from children born within a marriage. Class of persons known as a class bequest. You can make a bequest to a class of persons such as all your grandchildren or all your nieces or all the ladies in your gardening club. When such a bequest is made, the entire bequest will go to all the grandchildren or perhaps all your surviving nieces, whether born before or after the will was drafted. Institutions, organizations also fall under those people that you can choose. You are allowed to nominate a specific organization, institution to inherit from your estate. You may donate all your clothes to a charitable organization or perhaps leave money to the SPCA. One of the things that I didn't touch in this presentation, I'm thinking about it now, is organ donation. Yeah, can be part of your will. And start to say, I will donate, when I die, my heart goes to the Heart Foundation. My knees go, my knees go to the knee, what are these? Kidneys would go to so-and-so or would go to this organization. Now that's un-African, but it has to be. We have to step up as Africans. We are the biggest beneficiaries of organ donors. We are the biggest beneficiaries, so we must start to think about contributing. You may be contributing your organs to save a family member that you didn't even think about. Yeah, you didn't think about a family member, but by donating, rather than burying your heart, why are you burying your heart if it can help someone? An example of such a bequest is as follows. I bequest 10,000 rands to the Shining Star Children's Home in Grahamstown. Persons excluded from inheriting. Who is not going to be inheriting? A person who intentionally and unlawfully causes the death of the testator. You can't kill me and think you're going to have benefit from my assets. The court will really go through that. If you have found you have been involved in that, you can't benefit. There's a raised hand.
Yeah, leadership will pick them up once you're done.
Okay.
Yeah, we're running out of time.
Excellent. Any person who writes the will or a part thereof for the testator can never be a beneficiary. So if you assist your mom to write a will, you must know that the day it comes up when your mother is no more there, that you were actually assisting your mother, you will be actually cut out of being a beneficiary. Also, as mentioned earlier, person signing as a witness to the will cannot inherit in terms of the will either. Now, part of your will is providing for the guardianship of your children in your will. Guardianship comes in two forms: natural guardian and legal guardian. Natural guardian is one of the parents in marriage. I must add that natural guardian is one of the parents in marriage. Biological parent within a marriage relationship, or what the law accepts as a marriage relationship. The law decides what is a marriage these days. We know that. So legal guardian, someone appointed by law to play the role of guardian. Let me go back to natural guardian. Or let me see if I have dealt when preparing will is the needs of your children. Yes. Now let me quickly deal with it here. Now, why is the natural guardianship only confined to married couples? It's because couples who are not married, but they have a child, would have had one of them as the guardian of the child. Particularly if you have went to court and fought over guardianship. If the other one is a sole guardian. If I'm a sole guardian, you are not, as the other parent, a natural guardian. When I die, the issue of guardianship will again have to go back to court, and the court will still need to determine. But it doesn't cut you out from applying to become the guardian. When dealing with the issue of care and control of children, the law provides two distinct forms of care and control: custody and guardianship. I think custody involves the day-to-day care and maintenance of a child, which includes providing for educational, emotional, and spiritual needs of the child. And guardianship involves the legal care of a child. It requires a person to look after and control the property of the child, as well as acting on behalf of the child in respect of any legal proceedings or decisions. It is important that you understand that if you are married, that you cannot appoint someone else in your will to be the guardian of your minor child, because the other spouse is a natural guardian. The other parent will become the guardian of your child. It is only if you had sole guardianship of your children before your last day that you can appoint someone else other than the other parent to be the guardian of your minor children. A person who would have sole guardianship if, for example, they never got married to the biological father or mother of the child. This does not mean you cannot contest guardianship. Whether the court will grant it or not will depend on the merits of your case. An example of a clause in a will providing for guardianship is as follows: upon my death, I nominate my sister, Alice Venkile, or failing her, my aunt Beatrice Beauty, to become the guardian of my minor children until they attain majority age. Such guardian will be exempted from furnishing security to the master for the appointment as such, because the master may ask for a bond of security to make sure that you don't do wrong things. It is also vitally important that you never leave your assets directly to a minor child. If you do this, the assets will be entrusted to the state by way of administering your child's inheritance through the guardian's fund. So if you leave assets to your child and your child is a minor, the state will take over to manage the child's assets. And the state may appoint a guardian for the child. A bequest is a gift or personal item, property, which you leave to a specific person in your will. Legacy, you may leave a specific amount of money to a specific person. This is known as legacy. In other words, a legacy is a cash bequest to a specific person. An example of a legacy in a will is as follows: I bequeath the following legacies: sum of 5,000 rands to my daughter, Thandi Mlomo, sum of 2,000 rands to my niece, Andrea Bolt, on the condition that she is not married at the time of my death. The difference between heir and beneficiary, I've dealt with that one. Now, there's a clause called a substitution of beneficiaries in a will that many people don't realize the importance of. Substitution of beneficiaries says, in your will, you are allowed to provide for the substitution of beneficiaries. This means nominating a second or a third person who will inherit the bequest in the event that the nominated beneficiary dies before you do, or perhaps that beneficiary is excluded from the inheriting for one reason or the other. And here is a clause that really is an example of a substitution clause. In the event of any of my children dying before receiving their inheritance in terms of this will, I direct that such inheritance shall devolve upon our grandchildren in equal shares. That's substitution. And you can have another clause that says, in the event our grandchildren, because you may have one grandchildren, in the event our grandchildren are not capable of inheriting, this will must devolve to my uncle or aunt or cousins and so on. So you substitute.
Okay.
Repudiation and adiation. When you are included in a will, you are not obligated to accept the bequest or the legacy. If the will leaves a debilitated house to you, which will cost you more money to fix it than the value of the house itself. The law entitles you to say, no, I'm declining, I'm declining the inheritance. So that is called repudiation. And the right to choose whether you want to accept the inheritance or not is called adiation. Persons excluded from inheriting. It is also accepted that anyone who coerces or forces the testator to bequeath something to them cannot inherit, as the will would be regarded as invalid. The will cannot be valid if the will does not reflect the true intentions and wishes of the testator. When planning for our last day, particularly the drafting of our wills, we often need to sit back and think about situations which may arise before we actually die, such as ill health and the need for continued medical attention. Have any of us actually answered the questions? And I'm now dealing with something called living wills and power of attorney. The questions are, if I were to get very ill and required hospital machinery, to keep me alive, would I want to continue living like that? Or do I want them to rather switch off the machines? These are questions that must go through your mind to make it easy for those who would be alive at that time. I know this. My younger brother stayed in a machine for 27 days in what is called a locked-in syndrome. Africans called it a cabbage. You are locked in your body. You can't hear, you can't see, you can't speak, you can't do anything, you can't move. So you are locked in your own body. And we had to take a decision that what's the point of keeping the machines? If God wants to keep him, let God keep him. Let's switch the machines and see what happens. If he dies, that's the will of God. If he lives, that's the will of God. Yeah. So you need to think about these things. For how long do I wish to be reliant on medical treatment to keep me alive? Or who would make medical decisions on my behalf if I was unable to do so? If you are married, who would help your wife? Is there someone that you think you want because your wife would be really dealing with this unfortunate situation, or your husband for that matter? Who is there? Rather than just leaving a family, you might say your GP must be the person, your lawyer must be the person who is involved in helping taking these decisions, or someone in the family who has the temperament and the emotional intelligence to deal with things like these. Yeah. These questions relate to end-of-life decisions, which require us to decide what needs to happen in certain unforeseen circumstances, such as being brain dead, surviving on life support, being unable to afford further medical treatment, being unable to make medical decisions. It is possible to answer them in the form of an advance directive, which is a legal document which sets out instructions regarding future medical decisions when we are no longer able to make them ourselves. There are two kinds of advance directives, namely the living will and the power of attorney. Living will, this legal document allows you to give instructions regarding the type of medical treatment you wish to receive when your quality of life has severely depreciated, or even instruction as to no medical treatment being received at all. Power of attorney legal document allows you to appoint someone whom you trust to make certain or even all decisions regarding your medical treatment in the event that you are unable to make such decisions yourself. This is the checklist of drafting your will. 1, give your full names and identity, state your address, state your marital status, and if married, give your marital regime, as well as ID number and full names of your spouse. Write down that it is your last will and testament, and that you revoke all other wills that you have made before this one. This is for precautions if you have not made any will. Name someone who you wish will be the executor. Set out in specific details how you want your property divided, giving the full names, addresses, ID numbers, and genders of persons you wish to inherit your belongings. If you have minor children, make provision for someone to look after them when you die, as well as providing for them financially. State any other last wishes you may have, such as how you want to be buried. When completed, get 2 competent witnesses. Must then initial each and every page of the will in front of both witnesses. You and your 2 witnesses must then sign on the last page of the will, and you must insert the date on which you all signed together. Make sure that you sign as close to the last line of writing in the will to avoid someone adding something in. State any other last wishes you may have, such as how you want, I duplicated that slide. When a person dies without leaving a will, that person, now I'm quickly dealing with interstate succession, which is a very short part. When a person dies without leaving a will, that person is said to have died interstate, and the assets and property of that person is distributed in terms of that act. In other words, the act will determine who inherits what. Should you die interstate, only certain people called heirs can inherit from your estate. The following persons qualify to inherit: your legal spouse, your biological or adopted children, and your blood relatives are what the law determines are the people who can be heirs. It is possible for a person to die completely intestate or only partly intestate. An example of the latter is where a testate specifically bequests one portion of his estate in a valid will, but does not deal with the rest of his or her estates. In this instance, the portion that has been bequeathed by will devolve. We've covered that part earlier on. Now, the Interstate Succession Act, as I said, Section 1(1), deals with these rules. So I call this rule number 1, which is Section 1(1)(a). This is where the deceased is survived by a spouse or spouses if it is customary law, but not by a descendant. So it's just your spouses who are left or your spouse. What happens in that situation? What is the interstate succession saying? The spouse or spouses will inherit the interstate estate. In the case where the deceased was a husband in a polygamous marriage, the surviving spouses will inherit in equal shares. Let's see what the example says. Example A, where the deceased was a spouse in a monogamous marriage, meaning there's one spouse, and was married in community of property and left no descendants. Amount available for distribution is 400,000. The surviving spouse is the only interstate heir, irrespective of the value of the estate. Because the spouses were married in community of property, the surviving spouse will receive 1/2 share, 1/2 of the balance for distribution, which is 200,000 by virtue of marriage in common of property. And the other half, 200,000 in terms of Section 11A of the Interstate Succession Act. That one, simple, straightforward. It doesn't even require a rule. I need a ruler. It's just straightforward, that one. Example 2, where the deceased was a spouse in a monogamous, once again, but you are married out of community of property, and there's 400,000 to be distributed. The surviving spouse is the only interstate heir, irrespective of the value of the estate. Because the deceased and surviving spouse were married out of community of property, the surviving spouse will inherit the whole balance for distribution in the amount of 400,000 in terms of Section 11A of the Interstate Succession Act. What this means is that Section 11A of the Interstate Succession Act does not distinguish in terms of property regime. It just says, if you are leaving a spouse, it does not distinguish. So it doesn't mean that because one spouse is going to be is out of community, is going to be disinherited in some way. Example 3, where the deceased is in a polygamous marriage and left no descendants, all the marriages are out of community of property. All polygamous marriages are out of community of property. I mean, it just makes sense. How do you marry in community of property with 5 wives? Doesn't make sense. It just complicates things. So all polygamous marriages are out of community of property. A and B, in terms of Section 1A1 of the Act as amended by the Constitutional Court decision in Bay and others versus Magistrate Kailicha and others in Section 3.1 of the Reform of Customary Law Succession Act, the 2 spouses of the deceased, C and D, will inherit the estate in equal shares to the exclusion of any other family members. Should the deceased be survived by more than 2 customary wives and not leave any descendants, then all the wives will inherit the estate in equal shares. Now, let me quickly run you through what the Constitutional Court case is. The case of Bear and others in Magistrate, it's a 2005 case. Bear was living with a man for 12 years. In fact, Bear is the wife. The deceased was living with this wife for 12 years. And they had 2 children that are theirs. And the husband died. They had a structure in a squatter camp, so to speak, but a properly built structure, and the guy receiving a grant from government, and he used that grant to buy property, material to build this structure well. And he died. And when he died, the father of the husband phoned the wife and said to the wife, I'm coming down to Cape Town. He lived in the Eastern Cape. I'm coming down to Cape Town. You must decide how are you going to deal with this situation, because I am going to sell that structure and kick you all out. And in terms of the Black Administrations Act, when a deceased dies, any inheritance was reserved for the closest blood relative of the deceased, the closest male blood relative of the deceased. Yes. The closest, it can be anyone as long as it's male. All the females, the wife and the daughters would be put aside. And these things still exist in our families today.
Wow.
There are some of us who think that if I die, my family just comes here to push my wife aside. Where do they come in? Where do they come in? Strictly speaking, they don't feature anywhere. If you have a wife or a husband, that's the person who is responsible for the estate.
Yes.
So that's what happened. And when this went to court, the court won it. In fact, the master applied the Black Administration Act, and it went up to the Constitutional Court, and the Constitutional Court declared the Black Administrations Act unconstitutional, and said that the Interstate Succession Act is what must be used to deal with the inheritance of that family. So that's how the Bear case worked. Example number D, where the deceased was a spouse in a polygamous marriage. This one is a bit complicated. Polygamous marriage and left no descendants. In this example, the deceased was married to the first spouse in community of property. And due to the fact that the husband failed to comply with the provisions of Section 7.6 of the Recognition of Customary Marriages Act 120 of 2000, the second marriage was deemed to be out of community of property in terms of the Ngwenyama and Maelana, another decision handed down by the SCA on June 2012. The amount available for distribution is 600,000. And this is how the distribution will work. In view of the fact that the deceased was married in community of property to his first spouse, the joint estate must first be divided before the rules of interstate succession can be applied. So C, the deceased first spouse, will receive one half of the balance of the distribution, namely 300,000. Thereafter, the remaining half share, which is 300,000, will be divided equally between the two spouses, with each receiving 150,000 in terms of Section 11A of the Act, read with Section 3.1 of the Reform of Customary Law of Succession and Regulation of Related Matters Act 11 of 2009. What this means is that the end result of the division of the estate is the spouse to whom the deceased was married in community of property will receive 450,000. And D, the spouse to whom the deceased was married out of community of property will receive 150,000. Rule number 2, whether deceased is survived by descendants but not by a spouse, the descendants or descendants will inherit the interstate equally. It's straightforward. There's nothing to deal with there. Each one of them will receive 100,000. Whether deceased is not survived by a spouse, but is survived by one child and 2 grandchildren, balance for distribution is 400,000. The deceased's children, D and E, will inherit the estate in equal shares of 200 each. Because E is pre-deceased, his or her descendants, J and K, will represent him on the 200,000, and they will each receive 100,000 each. So at the top, the distribution will be in terms of direct, and at the bottom, the grandchildren will represent their parent and will receive whatever their parent was receiving in equal shares. Rule number 3, which is the last rule that I'm dealing with. Whether deceased is survived by a spouse or spouses as well as descendants, each spouse will inherit 250 or a child's share, whichever is greater, and the children, the balance of the estate. Now let me give an example. I didn't give an example on this one. I didn't finish all the rules, my leader, because I'm giving you just examples of how this thing
Okay.
will work. But let me give you an example on rule number 3. If the spouse, if the deceased is survived by a spouse and really 2 children, and there's 500,000 to be divided. Firstly, and they are married in community of property. The first thing that will happen, the 250,000 in terms of community of property will be put aside for the surviving spouse. And there's 250,000 that is available for now the 3 of them. But before you divide the 250,000, you have to calculate what the law says is a child share, because the law says if a spouse is in that situation, the spouse receives the half share in terms of community of property, and then a child share in terms of section 11C of the Interstate Succession Act. Now, there's 250 that is available. The child share is regarded in law as 250,000 or more. So if there's 250,000, there's nothing to divide. The 250,000 goes to the wife, goes to the surviving spouse. The children receive nothing. That's how the law, section 311C, rule 3 is applicable.
Wow.
I think that rules 4 to 9 is really in the Act. I'm sure I'm talking to people here who by now, I'm sure they must have Googled the Act, and they have the Act in front of them. And it's an Act, very small, it's 3 pages, written on both sides. And strictly speaking, you can look at that Act and see how it works. May God bless you.
Thank you, my leader. Thank you very, very much. Powerful presentation, very detailed. I mean, this is stuff that people pay for, and you spared your time to come and give it to us for free, share with the nation. That's what we call leadership. We truly, really appreciate what you have done, and we will forever be grateful in SALGC, the SALGC community, for what you have done. And we hope that this is not the first and the last, this is not the last time we ever see you here. We're grateful that you are even willing to share this knowledge with us so that I can distribute it to all our members. I know normally more live radio will go away at 6 o'clock because they've got a jazz session coming. So for them, when they go, we are grateful for what they have done and their listeners. And I'm sure they are grateful for this great show. This opens us to questions to those who have questions. I saw there were hands that were coming up, and I really tried to mute them because I needed you to finish first. So it's time for you guys to raise hands now. Let's see if you can take your questions before the program closes, the lecture closes. Please, leaders, check for me also on Facebook if there's any questions. There's Tamsanga, Ngula Leadership, over to you. Please unmute yourself and ask your question. Unmute yourself, my leader. Yes.
Hello. Hello.
Yes, we can hear you.
I'm sorry, I was not raising a hand. I was just clapping for the presentation, for the good presentation.
Oh, okay.
Maybe I pressed the wrong button.
Okay. No, wonderful. That says how much great the presentation was. I see on the notes at the bottom there, there's Matiana Makhoba. She says, profound and insightful presentation. She's thankful for that. Ubongani Kaba says, we can hear you. Or I think that was at the time the network was bad on my side, and I thought it was you. Umenkosazana Ndlovu says, thank you for the great presentation. As an expiring lawyer myself, the information will come in very, very handy. So any questions, if there's any questions, please Let's see when the upcoming lawyers here, my leader. This is incredible knowledge sharing. Leadership Zingisa is here. Leadership Zingisa, over to you, sir. Mrs.
Yes,
Osam.
just one question.
Yes.
What happens if the executor reneges on his duties or her duties?
Good question.
Yes,
Did you get that, leader?
yes, I've heard the question. The executor works for the master of the High Court, not the family.
Okay.
That's one of the things that people don't realize, that the executor, because is appointed by the master of the High Court, he actually reports to the master of the High Court. The family is a stakeholder, a beneficiary of the work of the executor. So the executor is, in inverted commas, legally obliged to interact with the family. Now, what happens if the executor really reneges?
So I thought because I appointed the executor myself.
Absolutely. So if you report to the master of the High Court, and the master of the High Court can actually dismiss the executor and appoint a new one. Still, you are going to make a recommendation or a nomination of an executor.
Thank you.
Great leadership. Before we go to Mrs. Osab, here's a question here before it pass on the notes here. George Mzali says, what extent can I assist my parents without being excluded as a beneficiary?
I think the truth of the matter is that wills that are written by our parents who really have not been to school and so on, we have assisted them. I think the law is trying to be careful here, that in the assisting you don't take a bigger share than your which is what happened in the spare of a moment. You hear your brother saying, "This is my house," and you don't know how did that happen. So how you can help, there are legal aids, there are churches. I don't know why churches don't have desks to help members of the churches with this kind of work, so that you can direct your parents to go and talk to someone who is neutral, not you. But you can't help it when your parents have confidence in you. They will from time to time talk to you. You are not really excluded, but you are. That's a warning. It's a precaution that you must know, that you don't get too involved to an extent that now you draft the will yourself. Yeah.
Great stuff. Mrs. Osam, the platform is yours. Please unmute yourself.
Thank you, Chair. Good afternoon, everyone. Mine is a quick question. So you are married in community of property, or let's say out of community of property. But basically the point I'm trying to get at is, then your spouse leaves the house to you, or the car to you, or whatever property to you, but it still owes, there's still outstanding amounts on the car or whatever it is from the financier, say the bank. What happens in that scenario? Because my understanding is, for as long as he doesn't own it, it belongs to the bank. It's only borrowed to him or to her. How do we handle such cases in the wills?
You can't bequeath something that is not yours. So Firstly, what will happen is that the executor will deal with the liquidity of the estate. If the liquidity of the estate is dealt with cash monies that he collected from payments of policies and so on, which strictly speaking don't form part of the deceased estate. But if through those payments he was able to pay off the car from the deceased estate, because the debt now is the debt of the deceased estate. If he can pay it off, then you will get it. But if he can't pay it off and the estate is not liquid or solvent, even if the car was left for you, it's going to be sold to deal with the solvency and the liquidity issues. So what am I saying? Until the deceased estate owns the car, it can't be yours. Yeah, the deceased estate must sort out whatever debt that is there and solve the issue of the debt of the car, and then the executor can transfer it to yourself as the beneficiary of the will of the deceased. Yeah.
Very interesting. Can I have a follow-up question on that?
Yes.
Yeah, my follow-up question would be, then it means if my spouse had left me that car, which is belonging to the bank takes it. So it means I am not inheriting that debt.
No, that debt, if the bank takes it, the debt will not be inherited by you. It would be let me rephrase that. Once again, we're going back to property regime, because property regime comes in here. If you are married in common of property, half of that debt is yours. Yeah, half of that debt of that car is yours. So the deceased estate, though, is not only inverted commas, because you are a very priority beneficiary in the deceased estate. The deceased estate is not prohibited of settling that debt, even though 50% of that debt is yours. The deceased estate can still settle it, rather than settling 50% and saying to you, because if it settle it, and whatever comes out of the net asset value of that deceased estate will come to you eventually.
Okay, I'm covered. Wow. Any other question? Any comment? Leaders, is there anything on Facebook? Yeah, it looks like the presentation was so detailed. There are no more questions. I see there's another one. He says, when a spouse dies while still employed, does the pension provident fund payout becomes part of the estate, or does it get paid direct to the surviving spouse? Perhaps the same question could be asked about the life cover payouts.
Yeah, well, I've just answered that question.
Yeah, this question is from
provident funds and pension funds
are
not part of the deceased estate, so they will be paid directly to the beneficiaries that are there. The provident fund will have a nomination form of beneficiaries, and the person would have nominated who the beneficiaries are, and therefore they will be paid directly to them. So is a life cover, unless the beneficiary is the deceased estate. There are people who nominate their deceased estate as a beneficiary. I have one of the estates that I'm dealing with where in a life cover, the deceased estate is the beneficiary.
Yes.
And this is a very interesting thing. I have a case recently where, this one is really, the wife have just got married to to the deceased. They are not even 2 years in marriage. Yeah, short of 2 years, the husband dies. And after the husband dies, he had a retirement annuity. And the husband has 5 children who are all adults. So the retirement annuity says to me, here are forms. Can you get all the benefit? Oh, the nomination form has nominated 3 of those children who were children of marriage, and 2 of them were not children of marriage. But because I'm the executor, I have to deal with all the children. And so the company where the pension, the retirement annuity is, send me form, says, can everyone who is a likely beneficiary complete these forms? And the children, all the 5 children complete the forms. Part of the questions that are asked is, how much have you been dependent on your father financially? And the kids answered, no, we are not, we were not. The trustees of that retirement annuity made a decision based on that actually the whole pension goes to the wife. Yeah.
Wow. Leadership, great.
Agreed.
Yeah, thank you so much. We have reached the end of the lecture today. In parting shot, just with all what you have said, and advice to people who have or would have wills and those whose families or parents have no wills, what is your advice in parting shot to everyone? With the experience of what we have seen in the interstates and the status passing of of someone's estate.
Well, all what I can say now is, guys, make sure you come again.
No, I thought you are on mute. You can go ahead.
Yes, no, I'm not. I'm not. Yes, all what I want to say is that as soon as we knock off here, I hope the majority of the people who are listening will start to say, how do I put together a will? How do I put together a will? And start that process as quickly as possible. We all know we are all but one step away from death. That's what Saul said to Jonathan when his father, in fact, that was his father said when Saul was after him, said, I'm just one step away from death. So all of us are one step away from death, and let's make sure that we do what we have to do. And as I say, I am leadership. You can leave my details. I am happy to assist those who would like to assist through ISSEGO. And in ISSEGO, we are not about money. So we're not going to charge people who want us to assist them putting together their wills. We'll help you do that. Yeah.
Can we type the details at the bottom there, maybe for everyone to pick them up?
Yeah, I'll definitely do that now. type them on the chat.
Yes.
Why not in the presentation itself?
Well, that's what I will also do that.
Okay, no, it's still in the presentation, it's fine.
Yeah,
All right, sure, okay.
yeah.
Until we realize that it is leadership to know these things and knowing that our affairs are in order, everything will be well.
Yeah, yeah. It's very painful. It's very painful to people.
We have.
I was just saying, do your loved ones a great service. Make sure that they don't quibble when you die. It's painful to quibble whilst people have a day because you did not have your things in order. Thank you, sir. Thank you very much. We are humbled. We are humbled by the invitation. Yeah.
I'm sure we'll still talk after this. Please, when you get the moment, I'll get the presentation from you, and then I'll distribute it to everyone who's here, whose details we have. Those that we don't have, would say people will send it to them via WhatsApp. We appreciate your help. We appreciate your time, and thank you very much also to the Siseko Institute. Thank you, leadership. God bless you.
Bless you too, man. Bless you too.
Thank you. And thank you everybody who has attended the presentation, More Live radio station, Facebook Live, and everyone who's here. We thank you very much for having made this time to be with us for this invaluable, knowledge that we have received today. We trust at SALGC that this information is not just coming. People take it and they use it. It benefits them to take us a notch further from where we are, because we really are moving slowly from where we are. We're taking us as a people forward and our families as well. Thank you very much for your time. Hope to see you in the week that follows after next. Thank you and God bless you.
Thank you.
Too. Bless you.
Thank you so much.
Amen and amen. Bye.
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 Thank you very much.